Please be seated. We will hear argument in 240258, the state of Texas against various amounts of money.
May it please the court, Ms. Baumgardner will present argument for the petitioner. Petitioners have reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. In the context of no evidence motions for summary judgment, the non-movant is required to, quote, produce evidence, which just means bringing evidence that's already in the trial court's file to the court's attention. And we did that when we expressly cited Officer Bacon's affidavit multiple times in our response. The Court of Appeals wrongly required the state to contemporaneously attach the response to our affidavit, but text and context show that there is no such stapler principle in Rule 166A. And because that's the most problematic aspect of the Court of Appeals opinion, I'd like to focus the bulk of my time today on talking about that. So let's just jump in and talk about the text of the rule. As I mentioned a moment ago, subpart I requires non-movants in the no evidence summary judgment context to produce evidence, and contemporaneous dictionaries like Black's 6th and 7th tell us that that just means bringing something to somebody's notice or attention. And we know that that's the right definition because of the interpretive comment from 1997, which says that we just have to point out evidence, not marshal our proof. So really the question that we're dealing with here is whether that idea of bringing something to somebody's attention necessitates attaching it. And the answer to that is no. First of all, like I just said, that notion of an attachment requirement is not inherent in what it means to bring something to someone's attention. But we also know from this court's decision in Lance that if something's on file with the trial court, you don't have to reattach it. Now, of course, Lance is talking about subpart C, but we know from text and context that subpart C is a rule about summary judgment procedures that apply to all types of summary judgment motions, both traditional and no evidence style. The textual clues for that start at the beginning of subpart C itself, where it just talks about, quote, the motion for summary judgment. It doesn't say which kind. So that phrase, both types of summary judgment motions fall within the ambit of that phrase. We also have the caption that refers to motion and proceedings thereon. And we know from the interpretive comment to subpart I that subpart I doesn't get bespoke summary judgment procedures. It follows the general summary judgment procedures. And we know that those are in subpart C. I think the best example of that is that the deadlines that are in subpart C for filing your summary judgment filings also apply to no evidence motions. I think everybody in this lawsuit agrees with that because as I read my friend on the other side's brief, they agree that our response was timely, but the reason our response was timely is because we complied with the subpart C deadlines. This court has also indicated in cases like the Steak and Shake case that the parties have cited that the deadlines in subpart C also apply to subpart I.
So let's say that you're right that you don't have to attach it if you point to it and it's on file, but is there any specificity requirements? So is it enough to just say, I point you to the 50-page affidavit which demonstrates that there's a fact issue?
Well, first of all, I want to, a couple parts to that answer. I want to be clear, first of all, that's not what happened here because we did expressly point to the parts of the affidavit on which we relied.
Sure, but would that be enough?
I think it would depend on really the size of the exhibit that you're pointing to. My friends on the other side have cited the Guthrie case, which deals with a 500-page deposition. Whether the kind of thing that we did here is sufficient for a case like Guthrie, where you've got very large exhibits, harder to say. There's a case from I think it's the 14th Court of Appeals, that Justice Guzman wrote this opinion when she was on the Court of Appeals. It's called Burns versus Canales, and we've cited it in our brief. And she says there, the point is not page numbers. The point is whether the trial court has some guidance. I think that is the right kind of area the right kind of phrasing that we're dealing with here, because how specific you have to be in pointing out evidence to the trial court is just going to vary, I think, based on the size of your exhibit. If it's a very short affidavit, I've seen Court of Appeals cases that said, I don't know, it's a 10-page affidavit, this is fine. And of course, we've cited cases just saying, here's the affidavit is sufficient. 500-page deposition, I don't know that would count, but we're much closer to the 10-page side here than the 500-page
And of course,
side.
it's particularly an acute problem in the trial courts because they don't have a lot of staff
That's right.
to help with this, right?
That's
I mean,
right.
we have law clerks and the courts
Right.
of appeals have law clerks. They don't have law clerks, so you need to
That's right.
help them out, right?
That's right, Your Honor. And
And
that's-
do so that they don't have to go and hunt around in the record.
That's right, Your Honor. This whole time, I'm dealing with the backstop of that principle that it is not appropriate to make the trial court go fishing. So I think that's also a backstop that we can, a principle that we can apply in the question that you asked me, Chief Justice Blacklock. But that's why I like that phrase, some guidance. It has enough flexibility such that you're not doing ticky-tack requirements like the Court of Appeals imposed on us here. The Court of Appeals said we hadn't specifically identified the evidence we were relying on because we didn't directly quote it, and we didn't use page numbers. Obviously, the rule does not require us to do that. It requires us to point to bring the evidence to the trial court's attention. And just how that looks and what that kind of guidance the trial court will need to find the evidence is just going to vary from circumstance to circumstance. And I think that the cases that both sides have cited in their briefing reflect that. We've cited cases that have shorter evidentiary records but are still much longer than the affidavit here. And the courts of appeals have said that was probably enough if you made a general reference to it. I don't think that will be okay every time, but it will just depend.
So in this case, it seems as though, regardless of whether the reasonably specific standard was met, that the trial court struck the affidavit simply because it wasn't attached, because the trial court described the affidavit, I think you say, as strong and more than enough. And so the trial court had, the ability to look through the affidavit to see if it was supportive of your response to the no evidence motion, but just said, I strike it.
That's right, Your
And
Honor.
so really what we have in front of us is the attachment requirement,
I think so, Your Honor.
or the lack thereof.
Sure, right, the attachment question.
The question.
I think that's right, and because, like you said, the trial court was pretty clear in its remarks that it just thought that we had to attach it. It didn't really get into that. I also don't think that this, how granularly specific do we have to be? I don't think that was an issue in the Court of Appeals. I didn't see it in anybody's issue statements in the Court of Appeals. So I think that's the main thing, but I'm glad that we addressed it because the Court of Appeals did talk about it.
Well, we've got to write a rule that says
That's
what you
right.
have to do. If we're going to say it's not attached, that tells people how do you point it out
That's right.
and what's enough for that. And I mean, there's tons of Court of Appeals cases, even where they do have law clerks that say, you got to point us to the evidence that there is. If you're saying there's sufficient evidence, you got to point it to
Right.
us, not just say, go hunt through this 2,000-page, reporter's record of the trial or whatever.
That's right, Your Honor.
And so, but do we really need to get into that here when, often we don't consider a trial court's oral explanations for its ruling, but it seems like if the question was the trial court aware of what you're talking about, then we would look to what the trial court said, and it said, this is a really strong affidavit. So is that enough for this purpose to say, well, the trial court considered it?
I think that
Or would have considered it, but for the attachment issue?
I think so, Your Honor. The court can certainly, we certainly don't oppose the court looking at the reporter's record. We also have some evidence in the clerk's record. We have, I believe, pages 334 through 35 and 342 through 44. We see that the trial court actually told the parties in an email that it intended to deny summary judgment on May 1st. So, of course, the submission date was May 26th, and then the trial court said, May 1st, I'm denying summary judgment. Now, somehow we had filed our response, but somehow my friend on the other side had not been served. So when that was pointed out to the trial court gave them some more time to reply. And the only thing that was in their reply was a couple of objections on which the trial court never ruled. And also, they were required to attach this, they didn't. So we also know, and then the trial court decided to grant summary judgment. So we also know from that exchange that that's why the trial court granted summary judgment as well. Reporter's record plus that evidence in the clerk's record. Additionally, I'd like to point out that Subpart C, the rule that's about procedures, is not itself giving rise to traditional MSJs. In other words, it's not just applicable to traditional motions for summary judgment, and we know that that's so because of the 1997 interpretive comment where the court says about halfway down the paragraph or refers about in that place to, quote, ordinary motions that arise under subparts A and B. So, and I think that's the best reading of the rule too, because if that's not so, and if subpart C itself is the thing giving rise to, or I guess activating is the phrase I've enjoyed using as I've prepped for this case, that if subpart C is the thing doing that, that allows litigants to file traditional motions for summary judgment. I'm not really sure what subparts A and B are doing in the rule. So from all of those things, we can see that, as I mentioned, subpart C is a rule about procedures that apply to all types of summary judgment motions, traditional and no evidence. And that tells us that this court's decision in Lance applies equally to subpart I and to no evidence motions. And that means that if it's on file, you're not required to reattach it. The Court of Appeals also had this idea that we were required to, sort of along the same lines, that we were required to contemporaneously file the affidavit with our response, but the rule actually points in the other direction. Subpart C allows litigants to file their summary judgment evidence late, after submission, but before judgment if you get leave of court, which sort of does away with that sort of contemporaneousness idea. Additionally, we see in subpart D that there are a list of a few ways that litigants can get summary judgment evidence on file if it's not on file yet. The court indicated in a case called McConaughey versus McConaughey, which is from 1994, that you can put evidence on file that's not on file yet by attaching it, but you don't have to do that under subpart D. And so that also does away with this sort of contemporaneousness idea.
Counsel, since you've had the pleasure of reading through our notes and comments, what is OSG's position on the weight that this court should afford those notes and comments when we're interpreting this rule or any other?
I know that generally, Your Honor, the comments are not, I guess I'll say I think this comment is unique because at the beginning of subpart I, the court expressly says this comment is to be used for construing and interpreting the rule. I'm not sure whether, it's hard to say in the absence of that phraseology whether a comment gets the same type of weight, but this comment is expressly supposed to be used for that purpose. My friend on the other side has argued in his brief that we aren't allowed to rely on the affidavit, not just because it wasn't attached, but because, in his view, it's not evidence, because it wasn't attached to our notice. But I am aware of no decision from this court, and my friend on the other side has cited no decision from this court that says that you're not allowed to rely on evidence simply because it is attached to the thing that's filling the function of the pleadings. Now, of course, it is black letter law in the state that pleadings themselves are not summary judgment evidence, even if they're sworn or verified with a couple of exceptions here and there. But we've never relied on our pleadings as evidence. We're relying on the affidavit. And the Court of Appeals decisions that my friend on the other side has relied on purport to rely on this court's decision in Hidalgo, but that's not what Hidalgo says. Hidalgo just says that summary judgment evidence, that pleadings themselves are not summary judgment evidence. Moreover, the argument that the Court of Appeals seemed to adopt and that my friend on the other side seems to be saying in his brief is that evidence isn't evidence unless you attach it to your MSJ. But summary judgment motions don't have magic powers, and something can be evidence even if it's not attached to that. Now, I think it would be improper if what someone did was attach an affidavit to a pleading that said, I, the affiant, swear that everything in the petition is true and correct, sign the affiant, and then attempted to rely on that as summary judgment proof. That seems a little bit more iffy to me because it seems like a bit of an attempt to bootstrap your pleadings into becoming summary judgment proof, but that's emphatically not what we have here. What we have here is an independent, standalone piece of evidence that we were required by law to attach.
So are there cases, what do the cases say that say, are there cases that say affidavits attached to pleadings are not evidence?
Some courts of appeals decisions have said that. I think the ones that my friend on the other side decided are Booker versus Siptak and then the Sugarland business case. I think those cases are wrong for the reasons that I've just explained. Hidalgo does not say that, and I'm not aware of a decision from this court that said that. Plus, some of the other courts of appeals have said, but you could still rely on it if you referenced it in a response, and we did that. We referenced the affidavit.
I'm struggling to understand the difference between formally an affidavit like this where everything's in the affidavit and an affidavit which is not unusual that you have a verified pleading.
That's
where
right.
There's an affidavit that says everything in here is true and correct. Right. Is it because it's not in the same document? I mean, that seems as equally a formal rule as it's not attached. So I guess I'm trying to figure out like where is formalism good and where is it bad in your view? I understand
the question, Your Honor, I think that the difference is, I view the difference as here this affidavit is independent. It's not that it's just like a separate document, but that it exists as an entity, if we can say it in that kind of metaphysical way, separately from from the petition, or the notice, which is sort of serving the function of our petition. And also, I find it difficult to believe that the legislature would have required us to attach this affidavit to our notice if we weren't allowed to rely on it as evidence. So those are sort of the two things I'm thinking about. It seems like it has an existence independent of the notice, if I can be that metaphysical about it. And also, I think it is relevant that we are required in 5904B to attach it. If the court has no further questions, that's all I have.
Any
We
further
ask that you
questions?
reverse, and I'll see the court on rebuttal.
Thank you. We'll hear from the respondent.
May it please the court, Mr. Isern will present argument for the respondent.
May it please the court, counsel. Mr. Busby, I absolutely think you're exactly right on this. There are cases that the state wants to say there's no cases that say that pleadings are not evidence. That's
No,
untrue.
I think what they said was that my question was about whether attachments to pleadings can be evidence.
Affidavits attached to pleadings are not evidence. This court has ruled on that for 50 years.
Which case?
That case, Your Honor. Hold on just a second, Judge. I had that pulled up and then I stood up here. Hidalgo says that pleadings are not evidence, but then there's a case that talks about directly about affidavits attached to pleadings are not evidence either. It is, sorry, Judge. I believe it's the Swift Energy case, Your Honor.
Isn't your argument really promoting form over substance? Because the whole point of summary judgment practice is that you grant summary judgment when there's no case, because there's no evidence to support the case, and that's really what we're talking about here. And so we certainly have always held generally as a general rule that form does not, that substance is what's important here.
Well, and that's a good point, Your Honor, because the substance is there was nothing attached to their response. Zero. There was no substance. The state
there was
wants
actually a quote, I think, good affidavit that
Well,
indicated that there is evidence.
But let me tell you about that. Where that comment came up was in their motion for leave that they have waived on appeal. They specifically said that in their brief. They've waived it on appeal. They're not arguing that. So the court should not consider what the trial judge said at that point, because that was after the summary judgment was already ruled on. We raised the issue because the state wants to say, all you have to do is say, well, look at the stuff on file. Okay, well, what? Well, the affidavit, the medical document, this, that. They can just say on file. That's not what the rule requires. What the rule requires is for the non-movant to produce evidence, not just something on file. So if you refer to a pleading with an affidavit, Justice Busby, that's not evidence. This court's already ruled that's not evidence.
The affidavit. And so I guess
But that's not
it
evidence
seems like
either.
there are cases saying that, yeah, if you attach it to a pleading, it's not evidence there, but you can use it later,
Sure.
right?
If you attach
So if they
it,
had attached it, you wouldn't say you can't use this because it was previously attached to a pleading, right?
Correct.
So then the question is, well, what does produce or on file or point out mean?
well, it's interesting. In one of the previous arguments today on the oil and gas case, there was a discussion about what does it mean to produce. The Amarillo Court of Appeals, quote, in their opinion, said a non-movement must do more than passively refer to other items on file. It must necessarily commit an affirmative act of presenting evidence to the trial court for consideration with the response. Produce, like in the oil and gas case, means to give something, to produce something, to prepare it, to give it to the court. The court, like you mentioned also at the beginning of this argument, is trial courts don't have briefing attorneys. Trial courts on any given day will hear a tax case, a criminal case, 3 or 4 pleas, a family law case, a summary judgment case, and then have a hearing on other civil or criminal matters. which is a court of general jurisdiction, so that's what they do. They don't have time to go look at the record and go look at the file. Because if we're gonna
Right,
do
but what
that,
we've said about error preservation is as long as you've made the trial court aware of what it is that you want them to look at, that's enough. So it seems like from the record that the trial court was aware of what was in the affidavit.
they were not aware until the motion for leave, because the affidavit was never given to the court until the state filed their first amended motion for leave. They never presented it even in their motion for leave. And that was after the summary judgment was granted. And we pointed that out in our reply. We filed our no evidence motion, they filed their response, we filed our reply and said, by the way, you don't have anything attached. And if you want to consider the motion for leave testimony, the state's attorney said, we know, we intentionally didn't attach it. That's what they said in the motion for leave. So when you intentionally don't do something, and even if you inadvertently did it, you should have raised that to the trial court's attention. If they'd have done that, the trial court probably would have given them leave, and they could have attached it. It's interesting to note that after, when they filed their motion for leave, and then they didn't attach the affidavit, then they filed their first amended, they filed 5 affidavits. None of those were on file. None of those were anywhere in the docket of the court at all. And there's no case that I'm aware of in the state of Texas that says under a no evidence motion for summary judgment, you don't have to attach anything, because it's different. 166AC motions for summary judgment, if I file that, I have the burden. I have to produce the evidence showing why I'm right. Rule 166AI shifts the burden. It says I can file a no evidence motion and say, no evidence of X, Y, and Z. Now, the rule says the non-movement has to produce evidence. That's a huge difference in AC and AI because of the burden shift. That is a gigantic change. It's not a change, it's what's been in effect for, golly, what is it now? 27 years. 27 years. 1997 was when no evidence motions were allowed. And there's not one case that says you don't have to attach evidence or that the non-movement doesn't have to produce evidence. There's not one.
So if the non-movement hadn't said there's the affidavit that's on file and here's the gist of what it is, then surely that would be right. They wouldn't have produced the evidence under 166AI, but they did do that.
They still haven't produced the evidence. That's not producing the evidence. That's talking about a different document. And what they talk about, if you look at, I think one of the justices asked the question about how specific do you have to be? What they said is, I think it was 5 different lines from Officer Bacon's affidavit that said, well, Officer Bacon says this, Officer Bacon says that, Officer Bacon says this.
So those are different things though, right? Because under your theory, if they were to have said in their response, on page 27, paragraph whatever, line whatever, you would still say, well, it's not produced. It's very specific, but it wasn't, that's correct. Am
That's right.
Accurately
That's correct. My objection to that would be the same thing, because we have a right to object to whatever evidence they have. Hearsay, conclusory fact statements which are not evidence, which this court has ruled are not evidence. And many courts of appeals have ruled the same way.
But the specificity point that you keep coming back to, and it's an attractive point, but I think it's entirely separate, because it's not a matter then of saying, well, it's just too hard. We're having to get the judges to rifle through things, and they can't figure out what anybody's talking about, and how can we expect some judge to read 500 pages? Well, I'm not saying that happened here. It might have been too brief, but the objection there is quite different from simply it wasn't stapled to it. You could staple it to it and be too brief about what it is in it that you want, or you could not staple it and be very specific about what it is. And you're saying that there are 2 different reasons why you should win in either of those circumstances.
And that's correct, Your Honor, because number 1, it wasn't attached. It wasn't produced. Number 2, it wasn't produced as evidence, because pleadings and affidavits attached to pleadings are not evidence. The courts have ruled that for years. It's very interesting also. I went back and looked. the Potter County District Attorney's Office, in the 17 cases before this one was ruled, attached their affidavits, every one of them. Officer Bacon was on 3 different cases. Since this case, they've had 5. They've attached an affidavit on every one of them.
Well, if you have the Court of Appeals, writing an opinion like the one in this case, I guess you probably are going to do that, but that doesn't necessarily mean that the law requires it.
But it does, Your Honor, and if the law didn't require it, then why'd they do it in the 17 cases before this one?
As they say themselves, it's maybe good practice, it's maybe helpful to do that. But again, that isn't necessarily, there are lots of things that counsel do for us in our briefing to us that's not required by the rules, but it's helpful to us, and that's probably good lawyering. But it isn't the case that we're going to reject a brief that doesn't do all of those things if it meets our minimum requirements. And so that's the real question I have. If we reject the notion that something that is on file and that is cited in the response in this way, if we say, no, that's just not categorically not evidence, you don't just automatically lose, what else is left? Anything? Is the specificity thing something that we have to address or not?
I don't think there is. I think under a no evidence motion for summary judgment where the burden shifts to the non-movement to produce evidence, they have to attach evidence. Because if we don't do that.
That's what I just said.
Yeah.
To please assume for the moment that we reject that.
If you reject that,
Yeah,
then.
I think if I'm not saying, I'm not predicting anything now, but suppose that the court were to hold that it's enough what they did in terms of the attachment. That counts as producing evidence, which is what the rule requires. Attach, it was done to comply with the requirement to produce evidence. At that point, do you lose, or is there something else we need to consider?
Well, I think we still win because we objected to the references in their response where we said that's not enough. And the court did overrule it. It didn't specifically overrule it, but it overruled it by granting the summary judgment because she was saying that isn't enough. Even what's in here isn't enough. So whether it was not attached and whether or not what was quoted from the affidavit, which wasn't quoted, it was just said, here's what he said, not in quotes, but the court said that's not enough. What you have done, the state, you haven't done enough. You haven't attached it, and what you've said in your reply is not enough. In fact, there are cases that also say that a party's, you cannot use your own pleadings to oppose a motion for summary judgment. You can't do that.
But they're using an affidavit that just happened at one point to have been attached to it.
Not in this one. If we take your scenario, Judge, that we're not saying it has to be attached. Okay, now it's just what they say in their response. Well, this court and many courts of appeals have said you can't use your own response as just the pleading itself as evidence. That's not evidence. Just because you say so, because if we're going to do that, then when somebody files a summary judgment, then I can file a response and say, no, you're wrong, we disagree, that there's a fact question, so the judge has to say, okay, well, he said there was a fact question, so even though he didn't attach anything, we're just going to go with that.
So, counsel, if I understand your argument, if I were looking for the piece of Rule 166A that would mean that you win, I assume it would be this last sentence in subsection I. The court must grant the motion unless the respondent produces summary judgment evidence raising a genuine issue of material fact. Is that right?
That's correct.
And I was added, I guess, in 1997 in contradistinction to the traditional summary judgment motion described in the earlier subsections.
That's correct. And the comment to 166
Right, and I've read the comment. And so I begins with the sentence, after adequate time for discovery, a party without presenting summary judgment evidence, right?
Yes.
So the same summary judgment evidence. And if we go back and we look up at subsection C, the kind of summary judgment evidence that a movement would normally have to put in here would be the things that are under the, I guess, sub I or Romanet 1 and Romanet 2. If the deposition transcripts, interrogatory answers, and other discovery responses referenced or set forth in the motion or response, and the pleadings, admissions, affidavits, stipulations of the parties, and authenticated or certified public records, if any, on file at the time of the hearing. So that defines the universe of summary judgment evidence, right? Not that the trial judge heard a hearsay objection. It's those sorts of things. They're in the court's file, and that's what summary judgment evidence is. Is that right?
Until you look at sub D that says you can only use those things that are on file along with a notice that they're going to be used as summary judgment evidence. That's what sub D says.
That's if they're not on file.
That's it, well, that's it, that's if they're not on file.
File, correct?
I'm sorry?
So, yeah, I hear your point about subsection D, but as Justice Boyd points out, that's if you haven't already gotten them into the court's possession. Then, when you file your summary judgment motion or your summary judgment papers, you need to make sure that the court could go and look at them if the court wanted to, right?
That's correct, except that, Judge, remember, and I don't remember what year it was, but years ago, clerks stopped accepting discovery. And that's when that's when they talked about things being not on file. That's when we started saying not on file, because you don't file discovery responses with the court anymore. We haven't done that for 20 years at least.
Right.
If not more. And so that's what that's talking about. But
then if you want to deprive a litigant of their day in court, then you can get those things in front of the trial court, make sure that the trial court could go and look at them if they wanted to, decide whether there's a genuine issue of material fact or not, and then decide, you're out, you're in, your trial date's here, you don't get one. Is that about right?
That's about right. But AI, the comment to AI says, this is not, the traditional rules don't apply to no evidence motions for summary judgment. There's a reason why it's titled no evidence by itself. It's not incorporated into sub C. It's not sub C I. It is 166A sub I. It's its own paragraph. And that's why, and that's what the way the practice has been since it got put in. People file separate motions all the time. A lot of the cases that the state cited were hybrid motions. And a lot of, and what you mentioned at the beginning here, after adequate time for discovery, a party without presenting summary judgment evidence. That's my side. I didn't attach anything to my motion. Mm-hmm. A lot of what the state talks about is cases where people filed summary judgments with evidence attached to their motion. That isn't what happened here. That's not what happened.
But I think the point is that summary judgment evidence means the same thing in I that it means in C.
Yeah, that
if it's produced, if it's attached, yes.
Or if it's on file in the words of C.
Or
Yeah,
referenced
but all the
or
cases,
set forth.
I'm sorry.
Or referenced or set forth, correct?
And the reference was not enough. The reference alone to 5 sentences out of a 44-page affidavit was not enough, and the court overruled it. The court said, you didn't attach it, and your response is not enough, so I'm granting summary judgment. The court did not abuse its discretion. That's the fundamental point is the trial court, you have to look at whether they abused their discretion in not going to look for something that they said was on file, and then our response, and they're looking at their reply and saying, no, that's not enough. Here's the problem that we're going to run into is, let's say we go back to your scenario where you don't have to attach anything. All you have to say is it's something on file. Okay, in medical cases, you've got 1,000 pages of record. I'll file a notice of filing each individual page, and you'll have 1,000 pleadings on file.
Why would you do that?
Because if the rule is all you have to do is reference what's on file.
Why would you file 1,000 of them though?
Well, I can file one because where I'm.
So if you did that, would a district court be in the position of saying, well, I want that document and I want to know the specific things that you're referring to? Could a district court do that, or is the district court like the emperor, live or die? Are those the only choices?
Pretty much, because I mean, there's all these lines of cases that talk about if it's too bulky, if there's too much evidence, if there's too much document, you have to specifically point to page, line, things like that.
Right, do you think that the affidavit in this case was too much to digest without specific references?
Yes.
43 pages?
Yes, I do, because it was a running narrative. There weren't paragraph numbers, there weren't page numbers, there weren't sections of it. Here's our investigation, here's our analysis, here's our things like that.
So if it had been half that, like 20 pages, would that have worked?
It depends on what the document is, and it depends on what it's attached to, because fundamentally that affidavit attached to a pleading is still not evidence. It's not evidence until they bring forward, they produce it, attaching it to their response.
Right,
And
it's
I can't
different-
object to their
It's different
response.
than a pleading, though, right? The
I'm sorry?
affidavit in this case is different than a pleading because it's a person with personal knowledge reciting facts within his personal knowledge about the claim that's been presented.
But
So
the
it's
affidavit-
different than an affidavit that says, like you would for a mandamus petition, that I verify that all the statements in my pleading are true and correct. That's a different thing because it doesn't have specific factual statements by a witness who's under oath, subject to penalties of perjury with specific factual statements.
And the affidavit wasn't filed by itself. It was never filed by itself. It was attached to their notice of forfeiture. And then we objected to that we filed our motion, they filed their response, we objected to it. The court said, you didn't attach it, and it wasn't sufficient to raise a fact issue. That's what the Court of Appeals said also.
If a plaintiff files a traditional motion for summary judgment and trial court denies it, says, no, I think there's a fact issue. And then after further discovery, the defendant files a no evidence motion for summary judgment that in light of the way the discovery is developed, there's even the evidence the plaintiff had previously relied on is no evidence to meet the legal burden here. Does the plaintiff in their response to that no evidence motion for summary judgment have to reattach all the evidence that they relied on in their traditional motion for summary judgment?
I'll answer that two ways. One way is best practice. Yes, I would attach everything again. That's what our firm would do. But there are cases at the courts of appeals. I'm not sure if there's a Supreme Court case on that. But since those documents were already part of another proceeding before the court, then you don't have to reattach them. That's what those cases say. I'm telling you what I would do, but there are cases that say you don't have to do that because, for example, one of the cases, I can't remember the name of it, but it was saying, I think it was the Deeds case, or not Deeds, the Lance case, where it had title documents, deeds. Those deeds were introduced as evidence in a prior hearing. So they were before the court. They were already evidence. They were before the court. So they didn't have to reattach them.
Thank you, counsel. Any further questions? All right, thank you, Mr. Isern. Ms. Baumgardner,
Thank you,
you
Your Honor.
have 5 minutes.
May it please the court, if by the case that my friend on the other side was referring to about whether affidavits attached to pleadings can still be evidence, if he's referring to the Regency case, I don't believe Regency says that either, but I will get with my friend on the other side after this and get the citation, and I'll take a look
He
at it
said
and write the court a
Swift
letter.
Energy, but
I thought Regency was like it had Swift in the name, but
Yeah,
maybe I've
maybe.
misremembered.
The same case.
Okay, great, thank you, Justice Boyd. Next, my friend on.
Are the pieces of the affidavit that are referenced or described in the response enough to defeat summary judgment, or do you need it to be the case that the court is obligated to look at the whole affidavit?
Well, Your Honor, I think the parts that are referenced in the response are sufficient. I'll also, remind the court there are parts of the affidavit that say, yes, I think what's in this response is enough. That's the answer to Your Honor's question.
There's not a lot in that response.
There's not a lot in the response, Your Honor, but what the rule requires us to have done is point out evidence, which is what we did. My friend on the other side is wrong about what produce means. Produce does not mean giving it to somebody because we have the comment that tells us that the best answer is pointing out evidence. You don't have to marshal your proof. So we know that definition of produce is incorrect. My friend on the other side has said in his brief and then just now that the proper standard of review for this case is abuse of discretion, but I certainly don't have to tell this court that the standard on which the court reviews summary judgments is de novo. The trial court did not consider the affidavit because she considered that she was legally barred from doing so. That is a pure question of law. There are no evidentiary rulings in this record, and the court can't infer them from the amended final judgment. For a good example as to why, I'll point the court to a case from, I believe, the Eastland Court or Texarkana from 2003 called Sunshine Mining and Refining versus Ernst &
Your
Young.
counsel points to the timing as evidence that the trial judge not only struck the affidavit, but also found it unhelpful in determining whether a fact issue existed because of lack of specificity. In other words, the summary judgment got granted, and then all this about the affidavit.
Well, Your Honor, we know that in granting summary judgment, she didn't strike the affidavit. She just chose not to consider it, and we can see that from her final judgment. We have not
Well,
relied
it also
on-
says in the record, this is the trial judge speaking, it needs to be attached and it wasn't, and that's what I was looking for.
Right.
So that suggests to me that what your friend on the other side is saying is the trial judge didn't go look at the affidavit at the time when you filed your first response because she was looking for it and she didn't see it, so she didn't consider it.
I think that I disagree with that, Justice Busby, and the reason why is the discussion you and I had in my opening argument about how the trial court initially planned to deny. In fact, told the parties she was denying summary judgment. The evidence that we referred to in our response was the affidavit, and so I don't see how she could have denied summary judgment or initially indicated that she was going to deny summary judgment if she had not looked at the affidavit and considered it sufficient, in addition to the reasons that she said on the record at the motion for leave hearing. I did not say that it is enough to just say, look at everything that's on file. What I said was you have to point it out to the trial court, and as I discussed with Chief Justice Blacklock, what that will look like will vary from situation to situation, but what's not sufficient is if you have a really big record to say, yeah, it's on file, go look at it. That's not our position. We also did not passively refer to anything on file, and we did do something affirmative because we pointed to the evidence that we were required to have pointed to. Let me see.
If it's in a 1,000-page document, and, in good faith, the lawyer opposing summary judgment thinks, well, it's just going to be so obvious if you just look at the table of contents of it, it's going to be very clear something like that. I'm not just telling the judge to read 1,000 pages, but I think I'm not going to insult the judge by doing it. Probably a bad idea, but if that happens and the judge doesn't think that that's sufficiently specific, what would happen then? Would summary judgment, a death penalty sanction, in essence, be properly granted, or is there some other step that would probably be taken?
I think the answer to that is going to depend on what subpart I says. 1 second. Unless the respondent produces evidence.
Yeah, so the evidence is produced in a sense. I mean,
right.
here's the 1,000 pages. It's
Right.
produced, but I'm not telling you enough. It seems like it's doing something different than produced.
I think that that's right, Your
And so is
Honor.
the remedy then something different also, like the judge having a local rule that says, here's how to do it, or the judge saying, I'm going to grant the motion unless you provide me specific, or something like that?
Sure. I
What
think-
other sources of law are there to govern that kind of question?
I've seen some Court of Appeals cases where the trial court said, hey, I can't find it, can you give me some references? I think that might be one answer to Your Honor's question. I'm afraid no cases are coming to me off the top of my head.
But
I've
does a
seen
trial
some.
court have to do that? I mean, they've got so many cases on their docket that they
Right.
have to before they, but I mean, if you refer blanketly to a 1,000-page affidavit and you don't point out the pages you want the trial court to read, it seems a little harsh to say to the trial court, well, you're going to get reversed if you don't, if you don't say to them, this is not specific, can you have another crack at it?
Sure. I'm out of time to answer the question. I think I'm just going to return to the words that I used earlier, which are some guidance from the Burns case. I think that's what is necessary. Like I said to Chief Justice Blacklock earlier, what that looks like varies from case to case. But in this 1,000-page circumstance, which I want to emphasize is not what we are dealing with here, more might be necessary. And I think that the phrase I think is most helpful is some guidance, even if that varies from case to case. We ask that you reverse.
Any further questions? Thank you, Ms. Baumgardner. The case is submitted, and that concludes the arguments for today. The marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.